I want to understand from Kamal Mitra Chinoy about Somnath Bharti's defense. He says, some associate of mine misused my name and my address got misused, my name got put over there. I don't know anything. Does it not strike you as strange that the law minister would not want to register an immediate case against this associate? 7-8 years have passed, he still hasn't filed a case. If somebody misuses your name and you end up having a link with porn websites, if you end up becoming one of the world's worst, most notorious spammers, surely you'll sue the pants of that guy.
Well, I would imagine if there was anything irregular, need not be millions of dollars, a person would move immediately. Now, how an associate managed to move millions of dollars from his home and from his probably digital network, that is something he'll have to answer. You don't have to be a lawyer to answer that question. It's a fairly commonsensical
okay,
kind
Pawan Duggal is a lawyer.
He's a law
not
minister.
Taking any sides, and I appreciate that, Mr. Duggal. If somebody had misused your name or my name, Prashantu's name, Ashish's name, and ended up with us being on the list of the most notorious spammers globally, only 3 Indians, one of them happens to be our law minister, would Somnath Bharti not have taken immediate, prompt and very stringent legal action against this associate?
Again, Rahul, I'll really refrain from making any comments because I have not seen the papers, but the fact still remains that you can only do so much as what the law provides. If the law is defective, well, that be it. If the law has been amended in 2008,
no, but I'm asking you a question.
Yeah.
If somebody misused Somnath's name, then surely the law minister will want to take some sort of action against this former associate?
Well, clearly, you'll have to apply the test of a reasonable man. A reasonable man with reasonable prudence, what he's expected to do under reasonable circumstances is what the Supreme Court says is the logical test to be applied. But again, in this facts, you'll have to quickly appreciate that I don't have to look at the papers. You've been showing up certain things. That's your version. I'm looking at Twitter. There are a lot of other comments simultaneously happening. So I think it's a matter that would require appropriate examination.
Which is the first step to an appropriate discussion is to hear from Somnath Bharti himself. These are companies registered in his name, Mr. Somnath Bharti, and I know that you're watching this broadcast tonight. Here is an open appeal, live on Headlines Today. You pick the time, you pick the place, I will come over tomorrow and interview you. Straight questions, no rhetoric, we'll put out the facts. I'd like to hear from you, and I think all of India wants to hear from you what you have to say in response to each of the specific questions our investigation throws up. Prashant.
So I think, Pawan, the simpler question, the way this could be put is, sure, spam itself is not mentioned or not covered in the IT Act of 2000, but what was covered was communications which carried prurient, pornography, for example. There was a mention of that. Now, in this case, we're talking of communication, spam, which is carrying a solicitation to something that leads to possible fraud. Presumably, if that is established, that was a violation of Indian law?
Well, let me tell you, the law was very clear. The law only, first of all, the Information Technology Act 2000 is silent on the word spam. Spam was nowhere a part of the objective of the law. Well, the law on pornography is well established. Section 67 of the IT Act says if you publish, if you transmit or cause to be published anything in the electronic form which is lascivious or which appeals to the prurient interests or the effect of which is to tend to deprave and corrupt the minds of those who, having regard to the relevant circumstances, are likely to see, read or hear the same. That is an offence under Section 67 of the Information Technology
Act. What
Act.
about email which seeks to defraud? Would that violate Section 420 of the IPC, for example?
Well, again, the question is, given the fact that it was the IT Act was thoroughly deficient.
What about IPC 420?
Well, IPC 420 could be applied in the event the relevant parameters of 420 would be made applicable there. But the question is, at the time when your mother legislation on the digital format is silent on spam,